like to call to order the regular meeting of the West Valley City Council and remind anyone who's here to speak today on any matter to make sure they sign up there in the back corner by Mr. Krim so that we can make sure that when that time comes they're appropriately acknowledged. By way of roll call, all members of the council are present today with the exception of Mr. Steve Vincent, who is ill and has asked to be excused. Item 3 today is our opening ceremony, and we have Council Member Steve Buehler who will be taking care of that for us today. Mr. Buehler.
Thank you, Mayor. You know, living in a democracy, a republic, I like to remember and study why and how we hold office and who we represent and how we should conduct ourselves. And I have some quotes that I would like to read, just a few quotes to help keep us grounded in some of those basic principles, and then ask you to stand with me and repeat the Pledge of Allegiance. Jeremy Bentham in 1768 said, "Without publicity, no good is permanent. Under the auspices of publicity, no evil can continue." James Madison said, "Knowledge will forever govern ignorance, and the people who mean to be their own governors must arm themselves with the power which knowledge gives." Lord Acton said, "Everything secret degenerates, even the administration of justice. Nothing is safe that does not show it can bear discussion and publicity." And Patrick Henry said, "The liberties of a people never were, nor ever will be, secure when the transactions of their rulers may be concealed from them." Please stand with me to recite the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
Thank you, Mr. Buehler. We come to item 5 tonight, which is the approval of the minutes of September 4th's regular meeting. Is there anyone here that would like to make a motion regarding that?
Move for approval of September 4th's regular meeting.
Second.
Okay, we have a motion and a second. Any discussion there? All in favor of approving the minutes, say aye.
Aye.
Minutes are approved. We come to our comment period, and this comment period lasts only 30 minutes at the most, and everyone who comes to speak in the comment period is asked to keep their comments to 5 minutes. Let's see, signing up on our sheet today, I see Steve Buehler. Would you like to speak as a member of the public or hold your comments till the City Council comments?
I didn't actually sign that, Mayor.
It says Steve Buehler. It's 2 chairs down for your address. We'll waive that then. Donna 5. Great, come on up.
Oh dear.
No, you're fine. It all seems more formal and scary than it really is, but we're just your neighbors. It's a long walk. Let's see, and Donna, we do need your address just for our records.
4644 Carnegie Tech Street.
Okay, thank you. So, yeah, up to 5 minutes. Go ahead.
Okay, I want to talk about an ordinance you have concerning animals and how many you can have. I agree on the 4 limit, but having somebody say you have 2 dogs and that's it, or 2 cats and that's it, and why can't we have 4 dogs or 4 cats? Someone told me when my son moved in with his dog that they could call and get me in trouble because I have 3 dogs in my house instead of 2. And I was just wondering, why is it that way?
Okay, thank you. When it comes to our city manager or council comment, maybe someone will give you an answer there.
Okay.
Thank you. Ms. 5 is the only one who signed up in our public comment period today, so we will go to our city manager comments. Mr. City Manager, I don't know if you want to address Ms. Fife's comment or anything else on your mind.
Sure, Mayor, I'll do that. Every ordinance is adopted at the city as a balance between regulation and protecting or allowing each individual citizen's rights, as we all know. And this is one of those ordinances that has been discussed many times and in many different ways and variations. And for some people, it would be some people would be completely responsible owners of 3 dogs or 4 dogs or 4 cats or whatever mix that might be that isn't currently allowed under the ordinance, but the ordinance is restricted to the 4 animals total and the 2 of each for a specific reason, and that is that as a whole and as a group across the city, the council and past councils have decided that that ordinance is appropriate given the level of control or responsibility that individual pet owners exercise. So for example, from a hearing from the resident standpoint, I in my position, although I sympathize with Ms. Fife, for example, in her request, why would I not be allowed to have the 3 dogs as opposed to 2 and 2? I'll probably have 10 calls or complaints that are on the side of too many dogs are running at large. My next door neighbor is not taking care of the number of dogs that they have. Or my next door neighbor has got way too many cats, whatever, they're in my yard, they're doing this, they're doing that. So the point I'm making there is that past councils have seen fit to adopt this ordinance based on what they have seen and judged correctly to be that balance in the ordinance between regulation and right.
Okay, thank you. We'll go to our city council comments. Is there anyone on the council who would like to comment on this or any other topic? We do have this raise from time to time, and I notice we've taken maybe a fresh look lately at our animal adoption efforts, and we've had the shelter open now on some Saturdays and different things. It's one that we've heard a little bit more about lately, and do you know, Mr. City Manager, are there other cities that handle this in a different way? Are there ways to mix and match the 4, if you will?
Thank you, Mayor. It's a good question. And yes, as you mentioned, we've had that discussion before and in fact have looked and checked out what other cities are doing, how their ordinances operate. And they do vary. They vary from city to city depending on a multitude of factors, I'm sure. Some do allow, my memory off the top of my head here, just exactly what Ms. Fife was asking for example. Total number of animals allowed as pets are the same as ours, but they don't particularly differ or care how many of one kind or the other, cat or dog, for example. But there's a lot of different variation, and it seems to be by reason of whatever suits that particular city's needs.
Yeah, thank you. Is there any on the council who would like our staff to bring this forward at a future date for a more formal consideration, or are we good with the status quo?
I would point out, Mayor, if I might, that that exact question has been raised before the council on a number of occasions, and there hasn't been an appetite from an overall stance of the group to readdress it.
Personally, I'm okay with the mix and match, but it sounds like I may be in the minority there. But we appreciate the clarifications there. And this topic does come up from time to time, and there may be a time when there is a disposition in this council to look at that again and perhaps do make a change. Ms. Fife, did you have a PS to add to your?
Yes, I wanted to know why it's limited. Well, you've limited to cats and dogs, but there's things like snakes, rodents, other kind of animals, but there's no limit on how many of those you could have.
We do have in other parts of the ordinance is spelling out for reptiles and other mammals and different things. And we could have our staff member who deals with that get with you if you want some further clarification. But we do actually spell out on some of those other animals some uses and limits. This does conclude our comment period tonight. We do come to item 7 now, which is a public hearing regarding application ZT 5-2012. And Mr. Pyle, if you could please introduce that.
Thank you, sir. So what we have before us tonight to be considered and taking input on the public hearing venue is a slight change to our sign ordinance.
And as the council knows, we go through a number of these considerations because the commercial sector, our business interests within the city are ever changing. The technology, the types of signs and advertising that are out there change. And so this is an area that we address quite a bit. And once again, just was mentioned in the other issue, there's a constant struggle between balance of right and regulation. And I think the council is very serious and has done a very good job of striking that balance between the two. Before us tonight, what we have is a slight modification that would actually ease the sign ordinance in terms of regulation. Basically what it is proposing to do is allow full video animation on electronic message signs with certain conditions attached. And as you remember, we talked about this last week and what those particulars are of this particular project, the project in question being the new theater over at the mall and a sign that they would like to put up there, which would advertise upcoming movies, trailers, that sort of thing.
Okay, thank you, sir. Is anyone here to speak on application ZT-5-2012, which is appertaining to ordinance 1239? Anyone? Okay, seeing no one, I close the public hearing on that topic. Council, what's your pleasure regarding this ordinance?
I would move for approval of ordinance number 12-39.
Second.
Okay, we have a motion and a second, so we have a live action potential here for ordinance 1239 to be approved. Any discussion or questions on that one? I will add, as I've been driving by the Megaplex construction, you can see where that sign will be there at the entrance and the distance from the road, and I think it'll actually be a very attractive addition to that gem we're receiving soon as a Megaplex. So I'm excited about this ordinance. Any other comments or questions? Okay, all in favor of approving 1239, say aye.
Aye.
That passes unanimously. We have a couple resolutions to be considered tonight. The first one, 12-132. Mr. Pyle, if you could introduce that one, please.
Thank you, sir. This resolution would allow the police department to purchase a crime scene digitizer through the use of Justice Assistant Grant, or JAG funds, would not exceed $75,000.
Okay, thank you. Council, what's your pleasure on this one?
I'll move for approval of resolution 12-132.
I'll second.
Okay, thank you. And as we discussed in our study meeting last week on this topic, this isn't from general fund, it's from the JAG grant. Is that correct?
That's correct, sir.
Okay. Any other questions or comments?
Just a comment, just to explain what the JAG grant is or where that comes from. That's a federally sponsored Department of Justice grant.
Thank you. All in favor of approving 12-132, say aye.
Aye.
That also passes unanimously. We have before us resolution 12-133. And in our study meeting, Mr. Pyle mentioned that the parties involved with this interlocal agreement may need some time to do a different version down the road. Is there anyone who'd like to make a motion regarding 12-133?
Mayor, I would move that we strike and remove Resolution 12-133 from consideration this evening.
Second.
Thank you. We have a motion and a second. All in favor of striking from the agenda Resolution 12-133, say aye.
Aye.
That also appears to be unanimous. We have one item of new business this evening. Mr. Pyle, if you'd like to introduce that, please.
Thank you, sir. This is consideration of an appeal from Mr. Nate Carlisle, who's here with us tonight from the Salt Lake Tribune regarding the denial of a records request. Just an introductory comment or two, and I also wanted to make some short explanation as to my action in this matter as well, Mayor, if I could. I'll be brief. So I believe this is either the third or the fourth grammar request for police records involving the Susan Powell case that we've heard. I've kind of lost count, but basically the source of the dispute centers around the media and an attorney purporting to represent the family needing access to these records for various purposes, one being public access to information, one being
investigation records for purposes of potential, litigation, those sorts of things. But I thought it would be helpful, or at least clarifying a little bit, just to point out what the process is and at least my part in the 2 steps up to your consideration of how that is proceeded. In each one of these appeals or requests, police department has reviewed the request, determined whether or not the records would be important or would be damaging to release them for the purposes of the investigation, the ongoing investigation they're conducting considering the Susan Powell case. So that request was first posed to the police department, denied in each one of these cases, and then appealed to myself. Myself, from the city manager's standpoint, have chosen in each one of those cases, including this one, to also further deny access and uphold the police department's appeal. And really, frankly, there are a number of different reasons that have been given for need to the records, purpose of the record, type of the records, class of the records, general nature of the records. I mean, there have been a lot of different ways and reasons that those have been requested, but they seem to generally and specifically center around one particular point, and that is that the media in particular, from various sources, including the Tribune, do not believe that an ongoing investigation is occurring. In fact, the Tribune said as much in a recent editorial where they believe, frankly, that the police department and or administration is simply not wanting to release for some purpose of covering incompetence or that sort of thing. Now, I'm not saying that in any kind of a derogatory manner. I'm just sort of reporting what the train of thought has been going up to this point. The point I wanted to make specific to that is I think it has been established clearly, both through the police department, to myself as a first level appeal, and also to the council on multiple occasions before this now, that an ongoing investigation is in fact occurring along multiple avenues and taking considerable amounts of time. Unfortunately, we would like to see this wrapped up as fast as anybody else, but we need to follow the investigation to its natural conclusion. And therefore, I have seen in my capacity the purpose and need to uphold that denial of releasing those records, and I would encourage the council to do so. Again, as you have in the past, I know that this is a difficult position for the council to be in. Yes, of course, we want to be as open as possible and release to the public, and it's a right of the public to be able to see the transactions of the government, absolutely. However, in this particular case, we're not saying that won't happen. That will happen. At the conclusion of the investigation, the situation will arise where any of those records that were associated with this closed case, just like any other criminal case of the tens of thousands that we deal with on annual and multiple year basis, will become available. All we're really asking for, and the media has supported us in that position. On the negative side of the position, they don't believe an investigation is going on, but the opposite of that is true. In many investigations, in fact, I can't think of any other investigation where the media has, from a request standpoint, have not forborne or had patience with us as we have naturally conducted that. They don't believe us in this particular case. You, however, have had access to see that information and know that's not the case, and that, from that standpoint, is where I'm urging you to make that decision.
If I can interject here, Wayne, maybe it would be also helpful if you just reviewed with us I guess just the procedure on it and our role in it, as well as the city attorney's role in it, and the applicant and response here tonight. You bet. Thanks, sir. Absolutely. So as I mentioned before, we've gone through that process, and any entity, media, attorneys, general public, are enabled to file a request for access to public records, which is called a GRAMA request. Government records and management access, so I believe, if I remember right, is the spelled out acronym. If that records request is denied, which is a very rare occasion, they have the right to appeal under our process and by state statute to the city manager, myself. If I'm to uphold that denial, then they then have the further appeal step to appeal that to the council, this body right here. The council is then takes under consideration in kind of a quasi-judicial manner, commentary coming from both sides of the case. In this case, you'll have Mr. Carlisle representing the Tribune and Mr. Gilmore representing the city. Council will hear both sides of that argument and then consider.
they could make a decision tonight, or you could delay that decision and take it under advisement and further consideration. And then at the conclusion of that period, which I'm always forgetting this, Eric, is it 5 days or 10 days? 5 West Valley City business days after tonight, the council is then required to issue a decision.
Okay. So we'll proceed with the next step there.
Okay, thank you, sir. And if I remember right, last time we did this, I think we had Eric kind of conduct that. But if I remember right, didn't we hear from the Tribune, from the appellant first?
Thank you, Mr. Carlisle.
Mr. Carlisle.
Thank you. I have some prepared remarks. First, just to address a couple things Mr. Pyle said. There is an ongoing investigation in the Susan Powell matter. I don't dispute that. I didn't dispute that last time I was here. My point last time and my point tonight will be that is not the issue. The term ongoing investigation is not even in the statute that has been cited for the denial here. The issue is whether these records can reasonably, and the word in the statute is reasonably, interfere with an investigation undertaken. Let me now move on to some prepared remarks I still have. First thing I want to address is why am I here tonight? What is different than when I was here 5 months ago? I'm asking for very specific documents this time. You have the list in front of you. It's short. If you want to, I can go over each one of them with you later. But it's important to note that I'm here for very specific documents because Grandma makes clear that the government has a duty to segregate records. So even if these records that I've listed are in a file that is at large classified as protected, there is still an obligation to review those specific documents and determine if those should be removed from the batch of protected files and made public. Also, last time I was here, Mr. Gilmore himself stated that he had not reviewed all the records in the file because it was so voluminous. That should not be an issue this time. As for the records I have specifically requested, most relate directly to Josh Powell, and as Mr. Gilmore, of course, himself said in the August 21 hearing, it's very obvious there's never going to be any criminal charges against Josh Powell. So I do not see a good reason to protect records that direct relate to Josh Powell. So what should you consider here tonight? With your permission at this point, I'd like to distribute something to each of the council members. May I approach and do that?
Yes, you may.
Okay, thank you. What you have there is a copy of the 2008 Utah Supreme Court opinion in a Grandma case. You can see the parties listed there. I'll encourage you to read the entire opinion, but I'll give a brief synopsis here. There were allegations of sexual harassment in the Salt Lake County Clerk's office. An investigation was conducted. It was not a criminal investigation, however, they cited the same statutes being cited here, as well as some others, with the argument that that release of records in that case would interfere with an investigation. The Utah Supreme Court rejected that argument and ordered the records released. Now I submit this to you to demonstrate that, first of all, that at each level of review, each level of appeal, the records are supposed to be reviewed, and that you can't. It's not sacrosanct that just because the record has been protected or been protected because it's an investigation, that it should remain that way. You still have to determine if the classification has merit. Okay. Also, the last two hearings in which the city council has addressed the Powell records, the question has been asked of Mr. Gilmore of when's the last time the police department worked on the case, or how recently they've worked on the case. I want to emphasize that is not a pertinent question. Again, I concede that it's an ongoing investigation, but the question is, are these records that I've requested, and they're specific records, reasonably going to jeopardize that investigation? And my last point here, and then I'll yield. It's been 5 months since I was here. It was a month since Ms. Bremner was here. I would contend that with each passing day, it weakens the argument to keep these records protected. Generally speaking, the longer something goes on, the less likely anybody's going to be charged with it, and the less value they have, less secrecy value they have. That's just been held throughout government, whether you're talking about local governments or classified records at the CIA. The older they get, the less useful they are to government, and the less reason you have to keep them protected. I would like the chance to respond to any argument Mr. Gilmore made or makes, sorry, and a closing argument too. Do I have that right, or should I have nothing else at this moment, but.
If there's more you want to say this
Okay.
evening, we'll give you that.
Okay, thank you. Oh, maybe I should ask, do you have questions of me at this point?
I would say at this point, well, I can't speak for everybody, but certainly throughout the evening we may
That's
back
fine.
up for questions too. Does anyone have a question they want to ask now?
Mayor, just as a point of order, I think we could do that. What we have done in the past is request is heard both sides and ask questions.
Yeah, and that's what I'd like to do too. Okay, thanks.
We're all getting an education on how to handle these types of hearings, it seems. I'd like to, I suppose I would like to open myself up to questions, but I guess I'd like to make a brief statement first. And that brief statement is similar to the statement that I made whenever we met here last August, I think, 21st, I believe it was, with Ann Bremner. Our bottom line continues to be that we want to solve this case. That is what we are actively pursuing. We are still pursuing it. It's not just an open case. There is a distinction in police speak between an open case, which means a case that is not solved, and an active case, meaning a case that is being pursued. This is not just an open case. This is an active case. And the fact that the case is active does mean that information contained in the case file that is being requested is sensitive, is case sensitive, and sensitive to the active, ongoing investigation. And therefore, it is protected. And the legislature recognized this in the Grandma statute. It carves that out in the Grandma statute, saying that records that are created or maintained for criminal enforcement purposes are protected if the release would interfere with the investigation of the case. And so the law is clear. And as we stated in this forum less than a month ago, calendar month ago, it might have been 4 weeks ago, we reiterate tonight that any release of documents in this case would jeopardize the ongoing investigation. I'm prepared, far more prepared, to address the types of concerns that council members brought up the first time we did this appeal. I was not as prepared as possibly I should be, and I appreciate the education that I received from that process. I thought I was here to just speak about the law, not about individual facts about the case, and hopefully I will give a better presentation if called upon to do so. I don't think it is necessary, however. I don't think that's the purview of this body. The purview of this body is to determine one thing. Is this an ongoing and active investigation, and would release of these documents interfere with the ongoing criminal investigation? And the answer to that is clearly yes, and therefore these records are protected. And with that, I'll submit.
Okay, thank you. Council members, any questions for either of these two gentlemen?
You know, I have a quick question for Mr. Carlisle, and it's kind of a housekeeping one, but it might be an easy one to just get off the books. In your request, you have 6, I believe, items requested, and in the city's response, item 6 was the response to you said that as of item number 6, there are no records or calls for service between the dates requested. Therefore, there are no records to forward to you. Are you satisfied with this answer on?
Yes, I am.
request for number
Yes.
6? Okay, thank you.
Thank you for that. That's a good clarification. Thank you.
So it's really the first 5 points where,
That's correct.
okay? Mr. Gilmore, question for you.
Yes, Mr. Mayor.
Based on the state case that we were given, it talks about how Chief Justice Durham says under grandma, the county, or perhaps in this case the city, bears the burden of proving that it properly classified the investigative report as non-public. And so obviously that's the claim that the city's making, is that this is non-public. On each of those 5 points, I mean, the first one, any recorded interviews or transcripts of interviews with Josh Powell. Is there, well, before I read all of them, is there any of those 5 points that
That have been made public?
right?
None have been made public.
And your argument is the same for all 5 points?
That none of them have been made public, yes.
Okay, so that's the status of them, but your argument is that regarding all 5, that none of them should be made public as well? So,
And none of them should be made public. They are sensitive to the ongoing investigation.
and so none are more, yeah, I won't re-ask the question 3 times, but.
If you're trying to get somewhere, yeah, I don't mind being.
I mean, all
asked the
5 of
question.
those are appertaining to the ongoing case.
It is, they are,
The active case.
absolutely.
Mayor, I have questions for Mr. Gilmore.
Okay.
Mr. Gilmore, is there any reason not to release records at this time other than it would interfere and damage the ongoing investigation?
It would interfere with the ongoing investigation, surely. All of those, I think, all of the things requested stand on firm ground under 63G 2-305-9A, which deals with the ongoing nature of the investigation. I think every single request, and I'm just talking about the first 5, not the 6th, because that was stipulated too. I think every one of the first 5 also can stand on the grounds of subsection B and C of 63G 305, and I think that the 3rd request can stand on grounds of A, B, C, D, and E of subsections A, B, C, D, and E of 63G 2-305.
Which reasons are?
Okay, you don't have the statute
Will
in front of you.
you just repeat that?
Okay, so I believe that all 5 requests stand on the ground of subsections A, B, and C of this statute. The statute is 63G 2-305, subsection 9. And so A, B, and C of that subsection of the code, all 5 of the statutes will stand on that. And in addition, the request to number 3 would include D and E as well.
So A is what?
A deals with ongoing investigations. B deals with, could reasonably be expected to interfere with enforcement proceedings. So if there were to be, for example, a grand jury convened, a preliminary hearing convened, any kind of hearing in order to get a search warrant, those types of things, it could interfere with that. B, that was B. C talks about depriving a person of a potential fair trial. And I believe all 3 of those subsections apply to all 5 of the items requested. Now, for item number 3, I also believe that subsections D and E also apply. And that is investigative techniques, procedures and policies not generally known outside of the government, and sources not generally known outside of the government. And to be even, that 3rd request deals with something that the West Valley City Police Department hasn't even acknowledged exists or happens. And so that would be even for other reasons, just something that would be very protected.
Mr. Gilmore,
Yes, sir.
please explain to me how, number 2, forensic reports of possible charred remains found in the West Utah desert would hamper the ongoing investigation, interfere with enforcement, or deprive somebody of a fair trial, just related to any reports of possible charred remains found in the West Utah desert.
And I believe I understand your question, and with all due respect, I believe that the correct answer is that no one can anticipate a document's individual worth to a future hearing, interview, or prosecution. When drafting these exceptions, the legislature made it clear that police agencies, police legal advisors, and even city councils aren't clairvoyant. That's why these exceptions were carved out in the Grandma statute. So the Grandma statute provides for their protection, thereby protecting the integrity of the case with any future hearing, interview, or prosecution. And that's what it comes down to, is I can't, if I could, Mr. Bueller, I wouldn't give you a more detailed answer to that, because that alone in this forum would be revealing something about the case that we don't want to reveal. So the Grandma statute allows me that room to stand on, to say that, hey, this is an ongoing investigation, this is sensitive material, we aren't requiring you to be clairvoyant and be able to look into this and look into the future and to see how this could affect a subsequent interview with a target of an investigation, and therefore it can remain protected. And that's probably a very unsatisfying answer to you, Mr. Bueller, because you have an inquisitive mind. I've been able to deduce that from our previous hearings. But that is the legal answer, and so it is the correct answer, but it is also the right answer. And I mean right for the integrity of this investigation.
There may be something in that report that through using that information in subsequent interviews, you may be able to trip somebody up.
Absolutely, and you may be able to, police use all kinds of techniques. Some of them, you see when you watch Cops and, Law and Order. Some of them you don't learn about until you become a prosecutor. Some of them that you might be aware of just from watching TV is the idea that, hey, buddy, we have a video of you stealing from that car from across the street that we know about, and we already know it's you. And so you make it easy on yourself and let us know. And those investigative techniques could be thwarted, could be propelled. I'm not saying here or there or anywhere, because I'm not commenting on the substance of the case, but it could, reasonably could, affect the ongoing investigation of this case.
Number 4, forensic reports concerning blood found in Powell home at 6254 West Sarah Circle. Is your answer to number 4 the same as your answer to number 2, or any different or broader?
It is very similar. It is very similar, but even more compelling, I believe. And I probably shouldn't even say that, because that reveals more. I don't want to reveal what I know about the case, but yes, my answer would be the same.
I mean, somebody's blood is either there or it's not.
Right.
And you want to keep close to the vest whose blood is there.
Absolutely. And where it was located, well, never mind, I shouldn't even, I don't want to, yeah.
Well, if nobody knows, when you investigate and you question, you can make up whose blood is there and where it's located, and only a certain handful of people, criminals and police officers.
And then we know, and then we're able to deduce what people know and how they had no ability to know that.
Right. I think that's all the questions I have.
I have a question of Mr. Carlisle. Sorry to have you pop up and down.
All right.
Just curious, if Josh Powell was still alive today, would you feel it right for all these items that you've requested? Just in your mind as a reporter.
I'm going to say probably not. No writing or grandma, because I think there would be a very matter of fact. I didn't request this stuff when Josh Powell was alive, for a lot of the reasons Mr. Gilmore laid out. But that was different then. Josh Powell was called the person of interest. There was a lot of suspicion on him, and I very easily could have wound up in criminal court. So that satisfy your answer? That's your question?
Yeah.
Right. Okay.
Now, if there's others besides Josh who may or may not have been involved, then do you still feel it's okay to ask for these items?
Your question implies that we already know the answer to that. I mean, it's been very ambiguous here. In fact, that's some of what I wanted to address on rebuttal. I can go ahead and start going through that now, and I think it might answer your question. Or do we need to wait, or how would you like to proceed?
You know, go ahead and rebut away, and there may be other questions after that even, and we'll make sure everyone has a chance to ask any question and say whatever they need to say today.
With regards to Mr. Gilmore laying out some scenarios, where they can supposedly question a witness better if these records aren't disclosed, the Supreme Court addressed that in the ruling you have. Salt Lake County wanted to keep those records protected in large part because they were worried they were going to jeopardize future investigations, and the Utah Supreme Court rejected that. They said that didn't have enough merit to warrant protection. And also, Mr. Gilmore, in describing these statutes, again omitted the word reasonably. The legislature put the word reasonably in there for a very good reason. I know I won't keep harping on that, I just wanted to point it out. The other thing I heard Mr. Gilmore say was West Valley City wants to solve the case. That's somewhat ambiguous here. Does that mean they want to find Susan Powell? Does that mean they want to charge someone criminally? I don't know how that's being defined here, and I don't know that the records at issue here would hurt one or both of those or neither. The other thing, Mr. Gilmore talked about, if records were made public that could harm hearings. Just because it's been made public doesn't mean it can't be introduced at a court proceeding as evidence or something like that. That's just not in the law anywhere. That can still be used in court. Okay. All right. May I clarify one thing you said? You said in item 3, which is the GPS data, that West Valley City has never acknowledged that. Okay. Well, I don't know if West Valley City has acknowledged it, but I saw the warrant signed by Judge Alba, and the Powells talked to me about that. Josh and Steve Powell both talked to me about that prior to their death. I mean, that occurred. There was a tracking device placed on a vehicle. Federal marshals and FBI came and picked that up and got it. I mean, it's not a secret. That has been disclosed, whether it's been by West Valley City or not. And so that is not a technique that is not, the crooks aren't going to know about now. Matter of fact, since then, there's been a U.S. Supreme Court ruling on GPS devices placed on vehicles. And so any crook that just pays attention to the news and hears about what the U.S. Supreme Court does knows now that law enforcement is in the habit of placing GPS devices on vehicles. Okay. Mayor Winter, did I sufficiently answer your question about whether still someone else could be charged, and would that change whether I'm requesting this information?
Yeah, let me just restate your answer to make sure I understood it clearly. So,
Okay.
In your opinion, if Josh Powell, the person of interest, was still alive, you wouldn't be making these requests because, in your mind, obviously, it would be hampering to the case, right?
Correct.
And if there may be others who were involved, you still feel it is okay to make these?
Involved how? That would.
I guess that's part of the question mark swirling, isn't it? Involved with the disappearance of Susan Powell.
I don't want to know
In your
a
opinion, as a
specific,
journalist, is it still appropriate to ask for those things?
if I knew a specific person that they were looking at, I would probably request documents that didn't pertain to that person, but it might still pertain to the Powell case. That's part of what I requested here. I requested documents specific to, some of the documents are specific to Josh Powell.
So if they came out, if the West Valley PD came out tomorrow and said, we have a person of interest and his name is John Doe, does that make you as a journalist want to back off from this sort of request, saying that there are other people that are alive that may be involved with this? Again, I'm dealing a little bit in a hypothetical realm, but I'm trying to understand from the journalism side how you're approaching this. If you found out tomorrow there's another person of interest who may have been
Yeah,
involved.
I understand the question. I'm trying to formulate an articulate answer in my mind. I'll answer your question. I would say at this point, no. It would not stop me from requesting documents. So, sorry, yes, I would request documents. But also, something very important has changed here since when Josh Powell was still alive. It's been 7 months now. So again, with the progression of time, just keep finding it less and less likely that these records are going to be pertinent, reasonably interfere with an investigation, even one that's ongoing.
Sorry for my hypothetical question.
No, I appreciate it. It's okay.
How we think about public records and when the rights are for things to come out. Mr. Bueller?
Mr. Carlisle, you know, you've been here before, and I know you want to see these records, and I don't want to play hide the ball, and I think records should be disclosed, but I just want to express, and hopefully you can gain or understand my perspective, which may or may not be shared by other members of this council. The police department is not investigating nobody, okay? And if an interview with Josh Powell says, it wasn't me, it was my friend Steve Bueller, that would come out in the transcript of that interview. If the GPS on Josh Powell's car showed he drove to my house 5 times that night, that would show up in those records. If the police and the district attorney's office were ready to charge somebody, those charges would be filed. That doesn't mean that they are not investigating and actively investigating actual suspects and building a case against actual suspects. And our interest, my interest, is to be open in government, but to protect investigations. And so my promise is to evaluate each of these points separately and help formulate a response. But that Josh Powell is dead has no bearing on the value of what he may have said or done from the time preceding Susan's disappearance to the date that he died.
Let me ask a question to you.
Sure.
Okay, why don't you think that's pertinent to whether the documents should be disclosed?
What? No, that's not what I meant to say.
Okay.
What he said and did not die with him. The implications of what he said and did and who he said things to and what he said things about, and those are all still important to an investigation to prove a case against other suspects. Just as I gave an example. He said, you know, I was with my buddy Steve Bueller. The police wouldn't want that out in the Tribune until they have investigated Steve Bueller and determined whether or not that's true.
Is this, again, if I may ask a question of you, is this a hypothetical, or do you know the records?
I do not know that the records reference my name, and I do not know that they do not reference my name.
I've got my
Okay.
fingers crossed for you.
Thank you.
Mr. Rushton?
You know, I have a question of our legal counsel, and I guess like Mr. Gilmore to maybe stand ready to respond as well, as this might be more up your alley. But so if you can kind of follow my train of thought here, is that there are cases out there that are no longer active, and releasing the information would not reasonably interfere. And if requested, it's I guess, reasonable to assume that there still might be information in documents like that that would be redacted or not included in a release. So with that in mind, I guess, who has, if the city council goes through this process and says, you know, item 3 looks like, you know, probably wouldn't interfere with A, B, C, or D, and, you know, but acknowledge that there may still be points in that would need to be concealed. Who's the source that has the discretion for the redaction of records that are deemed to be public?
Mr. Gilmore, would you mind taking the first crack at that?
No, I wouldn't mind at all.
Because I'm assuming it's not, you know, the city council that.
Eric is my boss,
Redact.
and therefore, I know the answer to the question.
Okay.
The way that it does work is, as a judicial body, you would make that decision. You would go through because under grandma, there are different classifications of records that will be kept from public purview. And that would be protected records, which is what we are arguing these records are in this case. And protected records can be broad, meaning the entire investigation. And then there are other types of records, they call them private records. That would be private information, your address, your home phone number, your date of birth, your social security, the VIN number on your car. Those would have to be, if you were to decide, hey, this case is no longer active, it's done, and a release were to be given, and if that were to happen 8 months from now, for example, that this case is no longer active, we have run its course, we have shopped it to every prosecutorial agency between here in Washington or wherever else, and nobody will take the evidence that we have and prosecute the case. Then the case could be released. It's no longer active, it could be released. However, then it would go through a process of redactions, taking out people's birth dates, social security numbers, VIN numbers on their cars, or other classified information. The way in which cities go about warrants for certain technical information, things like that, police procedures and stuff like that would still be redacted out of that document. You guys would be able to view the document in its entirety and see why it is we'd redact it. You guys might say, hey, that doesn't need to be redacted, and we, as a police department, still no, that does need to be redacted. We could appeal what you say to the district court and say, district court, you're more familiar with how these things work, overrule the city council and keep that redacted, and that's the process it would go to.
So we would, I'm sorry, Corey.
No, I mean, you're probably going to ask what I'm going to ask.
We would take the entire document, and if we decided it needed a redaction, propose those redactions so that the police department could have a chance to appeal that before it was released to the public.
No, you would, well, this is how it would work, and what I would recommend to you, and you'd have to talk with your counsel, what I would recommend to you is if this case did become inactive and therefore no longer protected, and you were going to release the file in its entirety, I would recommend to you that you dedicate the time before releasing it in its entirety to start redacting out private information. Otherwise, you could get sued by those private individuals for a breach of their privacy. And so you'd have to go, that process would have to be gone through. And then if we would have looked at what it is that you were to decide, we could appeal it to the district court. If we disagreed with you, and that could be appealed to the Utah Court of Appeals and all the way up to the Utah Supreme Court.
But tonight, we're deciding whether 5 classifications of records or reports should be protected.
Tonight, you are deciding whether or not 5 separate requests should remain protected, yes.
And if we decide to review those documents, they should be given to us unredacted because we would decide what in those documents is revealed or not revealed.
Now you're getting beyond my expertise. I just know the appeals process.
Pose that question to Eric then.
Well, it also sounds like that there's certain hard, fast, private information that's scratched out regardless.
No matter what.
But then there is a level of things that there is some discretion that it's either by attorney in the city or the city council itself or an appellate court.
And to give you the background, whenever those district court documents were going through their process of potentially being released, we sat down with the Salt Lake Tribune attorneys and we argued line by line. It was a 6-month process, arguing line by line what should stay redacted and what shouldn't, and for various reasons. There wasn't much argument from the Salt Lake Tribune when it came to private, personal information, things that shouldn't be revealed, has no bearing on anything. if somebody sought psychiatric help, if somebody got an abortion, if somebody got, whatever, you know what I mean? Like those types of things gets redacted out, nobody's going to argue about it. Then there comes to police procedures in which the techniques police use and those types of things, more arguments, but that stuff pretty much, stays redacted too. And we would argue that in a court, and I think, based on my experience, would prevail, and we did prevail. And then it comes down to protecting the integrity of the case. And what happened in that process is the Salt Lake Tribune's lawyers came forward with stuff that was already released in Washington and said, you're asking to keep protected stuff that is already out in the public purview, so therefore you cannot conceivably argue anymore that these things will help you with your investigation because somebody shouldn't have known that information. And then those are the items that did prevail on those items, and they became unredacted.
Did you have anything else, I guess, to add to that?
I think just to sum it up in answer to Councilman Butte and Councilman Rushton's question is I think the original question about who would be doing the redactions on the documents that are in question tonight, it would be the council as on many of those items working with me as your counsel.
And I would urge you to not engage in that process, as this is a protected record. All of these records are protected due to the ongoing nature of the investigation. I would urge you to not even begin that process due to the sensitivity of the ongoing investigation. And I'm surprised that of a couple of things that I heard from Mr. Carlisle today. I would like to see a copy of the document that you say that you have. I would like to find out who you say you got it from, and I would like to forward it on.
And you guys can go argue about that later. But Mr. Gilmore, I mean, should the investigating officer that sees something believe he should keep that from a sergeant, and the sergeant should keep it from the lieutenant keep it from the captain, and keep it from the chief of police?
No.
We're part of the police department.
We're
the public's part of the police department. We're the boss of the chief of police. And it offends me, frankly, representing the public, that you're saying, we don't want you guys to see the documents because they're too sensitive for you.
That's not what I'm saying to you. I am not saying that to you. If you wanted to review the documents that are being requested, frankly, if you gave me 30 minutes in a room, I could explain to you the entire case and the reason why these documents need to be protected. I could do it in 30 minutes. I don't want to do that. The more people who find out about an active investigation is detrimental to the security of that investigation.
Well, and certainly for our purposes, that would not be appropriate to do that out of Mr. Carlisle's.
Right.
Because
exactly. We have never done that. We have never talked.
Right. We've only spoken to you here.
I've never spoken to any of you. You don't know me, and I don't really know you outside of the 3 times I've appeared in front of you.
Okay, and we'll expect to see you again and again and again, too.
And Councilman Bueller, I think, kind of to maybe what I'm getting at here a little bit is that I think it's a little more black and white when this is protected or it's not protected. But then when we start getting into each and every word in a thing, if we did look at it, then it's 6 different opinions on certain words. Right. And is there the Steve Bueller opinion and the Corey Rushton opinion and the Frank Lang opinion? And so I just as a process on this of how this works out and seeing in some ways of how we're kind of the guinea pig testing ground for grandma laws in the state of Utah. I think that's an important thing to point out during these proceedings. So
I'm not trying to be belligerent, and I'm not trying to be an obstructionist. I'm not trying to do those things. I am trying to be cautious. It's not because the police department has something to hide. It's not that. We believe, though, that because of the ongoing nature of this investigation, this case merits discretion. It merits the caution. Legally and morally, we think that it merits remaining protected so that we can follow this process through. That's where we stand. Do you have any more questions for me? I can pontificate all night if you want to about this.
I guess if you're doing that, and this is maybe getting a little off this, but
that's dangerous.
Mr. Carlisle brought together this Supreme Court case from from 2008, and I know it's unfair to all of a sudden
It is.
throw this on you with all 20 pages of it. But I think one thing that's come up in the past that we have talked about and deliberated on, and I think there's been a question mark on this part, even though other cases of the appeal were pretty clear to us. I think it's safe to say is that in this, and if you could just comment on this, like I said, since you're feeling the vibe here, is that the state Supreme Court says that the county or municipality bears the burden of proving that properly classified the investigative report is non-public.
Yeah, and that's very easy. I think what it's addressing there is, do we protect all of our police reports on a consistent basis? And if we do, because what I think what they're protecting against is, normally because there are police departments. I mean, I remember when Ogden PD, that big shooting that happened up in Ogden, and son of a gun, like 2 days later, the whole video of the dang thing was released to the public. And I remember D. Smith, is that his name, the county DA up there going, I don't know who released that, but now I don't know if somebody can get a fair trial in our jurisdiction. I'm very upset about that being released. So there are other agencies that, generally they're smaller agencies, no offense to other agencies, less professional than the West Valley City Police Department is, less professional agencies that just, here it all is. And it does mess up their cases. We follow the law, we watch the law, we follow the trends in the law to protect. And so we have labeled all of our police reports protected documents up and until the time that they go to trial and have to be turned over by way of discovery, or they're inactive, meaning we no longer are pursuing any kind of case. Everything has gone dry. This case has not gone dry. It is an active investigation.
I have a question for Mr. Carlisle.
Thank you, and I would like to address.
A response?
Well, I'll take your question first. I just wanted to make you aware that I would like a chance to respond at some point. But why don't you go ahead, please?
Okay. Your motives for asking for this is, I would assume, pretty obvious. You want to have a good story about a hot topic of the day. But I also feel, well, hold on. But I also feel you're asking in part because you feel it's your duty as a journalist, as part of the Fourth Estate, to play that watchdog role. And I'm just trying to understand your motives and if there are some concerns that we could help assuage as elected officials. So I'm curious. I know it's an obvious question.
I'm here for the watchdog role. I don't need a hot story. I'd be chasing the Kate Middleton photos if I wanted a hot story.
Right.
I'm here as a watchdog role. Does that answer your question, or would you like me to elaborate on that? Okay.
Yeah, so I assume you're doing this out of your duty as the media is to be a watchdog. How do you, as a journalist, feel that, okay, if there is an active case, and it truly is active, and they truly are working on it every week, how do you verify, in your opinion, what level of verification is necessary to prove that that's still active to the point where you'd say, gosh, I don't think we should release this info to the public? Is it you as a journalist looking at that information and making that call? Is it us as elected officials, as the people's representatives, taking kind of an independent third-party look at that information, saying, boy, we really shouldn't make this public? Just curious, in your opinion as a journalist.
Active is not the issue. The issue is, would the release of the records reasonably hurt the investigation? Again, I concede that the case is active.
We'll ask you that question then. To look at the information, to look at the answers to the questions you're asking, and make that determination of, wow, these reasonably would affect the investigation. If that's a call that only a journalist can make, is that a call that elected officials as the people's representatives can make? Who, in your opinion, can make that call as a legitimate watchdog?
I think you can make that if you choose to look at these in camera. Now, that's something I was going to say, that I think if you want to just go ahead and order them released now, by all means go ahead. But I would say that rather than uphold the denials, you should review these first, because I keep hearing Mr. Gilmore say that every scrap of paper related to this investigation is protected and could hamper the investigation if it's released. That is not reasonable. I mean, I just don't see how everything could be pertinent here. And again, you have the duty to review individual records and segregate them from the larger batch of protected documents. And that's what I've asked you to do here tonight. And I think it's reasonable that you go ahead and look at them. I take Mr. Gilmore's point about them not wanting too many eyes looking at documents they think are valuable, but if you don't take that look, you're just taking the police department's word for it, and that's not why we're here tonight. And again, that's talked about in the Supreme Court opinion, that there is supposed to be an independent review at each level of appeal. If we were in a courtroom, it'd be called de novo. Can I say one thing about the Ogden video?
Yeah, answer my question.
Okay, as for the Ogden video, I've covered that up there too. I don't agree with the interpretation that some smaller, less sophisticated department released something by mistake or in error or did something they shouldn't have done. Ogden released that video because they thought it would not reasonably interfere with investigation. They removed that video from the larger protective file and disseminated it. I won't make you go look at all the video like I did because it lasts 3 or 4 hours, but let me tell you what you don't see in any of the video. You don't see any of that narcotic strike force knocking or announcing themselves and going into the house. You don't see any shooting inside the house, which is where the alleged crimes actually took place. The only video you see is the aftermath. I mean, they're dragging away wounded police officers. They have the suspect in handcuffs or walking him away. You don't see any of the alleged crimes on that video, and so that is not it's not fair to say that they made some kind of mistake in releasing that. Ogden, to the contrary, Ogden took a thoughtful look at that video and realized they should segregate it, that it should be made public. They keep everything else protected, and I know because I've been following that case, and there's still a lot of stuff we don't know in that case.
Okay, thank you. Does anyone have any other questions for anybody?
And I think if nobody else does, then I would move that we deliberate at 5 minutes concluding this meeting to meet with our attorney and deliberate on what we've heard tonight.
Okay,
Second.
Have a second there? Any discussion? All in favor of that motion, say aye.
Aye.
That passes. Thank you both.
Thank you.
And Mayor, I know we're about done tonight, but I've noticed that Mr. Given and a presumed scout group have entered the council chamber, so maybe we ought to do our normal thing and go back to item 4 of special recognitions.
Thank you, Mr. Rushton. We always welcome the scouts when they're here with us. Is there one of the boys who'd like to come to the microphone and tell us your name and introduce your troop and what badge you're working on tonight? Come on up.
Say your last name clearly, please.
I'm Dan Nordfeld, and we're Troop 913, and we're working on the communication merit badge.
Great. Well, thank you. Welcome, boys. Appreciate you coming by.
We went to a Granite School District Board meeting, but it's not tonight.
Oh, so you hustled here. Well, you got the last item on the agenda. It's probably the more newsworthy one. And so we appreciate you guys coming. All right, we come to item 10, which is executive session. Any need for that today? Okay, and we come to item 11, which is to adjourn. And for the earlier motion, the council will reconvene in 5 minutes for deliberation.